This is our final panel for Friday. I'm Ann Joseph O'Connell, and I'll be moderating. So I just want to thank Jed, Michael, and especially Morgan for organizing this conference. And what I'm going to do is just quickly preview how the panel will run, because it is going to be different than the preceding two panels. It also, as a preview, will not be highly contentious, I think. Okay, so what we're going to do is, due to a positive COVID test of one of the original papers, we have only two papers for this panel. So Amanda Tyler is going to give a short presentation about her paper and larger body of work, and then Bijal Shah and Chris Walker will provide some brief comments with regard to Amanda's paper. Then we'll turn to Bernie Myler and some of her work that she's been doing related to the topic of this panel. And then I and perhaps Chris will provide some comments. And then, so as not to end obscenely early, but perhaps a little bit early because it is the end of the day, I have a few broader questions to pose to the panel. And then we might leave the founding era entirely and talk about emergencies and COVID. So we'll start with Amanda.
Okay. Thank you so much. It's such a pleasure to be here. And I have to say, as I was thinking about this today, driving over here from Berkeley, the last event I did with the Constitution Center was on Zoom during COVID with Ann, and I cannot tell you how happy I am to be in a room with real people and in person. It's just a pleasure and a privilege to be with all of you. So thank you, and thank you to the organizers very much. You know, I was thinking as I was listening to Eric Nelson this morning talking about Article 2 and the contentiousness of the threats and how they were perceived, and it got me thinking about how history is messy. It is indeed messy, and I've written some about this myself, particularly in the context of Article 3. There are so many things we take as, forgive me for using the phrase, as gospel in the context of Article 3, that when you go back and you look around the founding period, you find we're very much up in the air. It's no surprise that some of the same things ring true when we talk about Article 2. After all, look how short it is. There's not a lot there, and if you really want to contrast our very short national Constitution, just read the California Constitution. Because when I was appointed to a position at UC Berkeley, I thought, well, gosh, I'm moving to my home state. I should actually read the state constitution. It's really long because it's really easy to amend under the initiative process. But it's quite a contrast, right? The level of detail. You know, Eric was talking about how people perceived threats coming in some camps from the presidency, in other camps from Congress. I'm going to tell a story that talks about both of those camps and both of those threats. It is noteworthy in that respect that Gouverneur Morris, who wrote the suspension clause, about which, surprise, surprise, I'm going to talk. I've written a lot about it, so some people in the room are not surprised. He said at the Constitutional Convention that the public liberty is in greater danger from legislative usurpations than from any other source, which tells you that there are these dueling narratives about this history. But it's because of that, and because Article 2 is so short, that I think it makes it important to look at context and to look at history. They help inform some of these debates. They help us tell a story about the purposes behind clauses. They help contextualize terms of art and practices, among other things, and that is certainly the case when it comes to the suspension clause, about which I'm going to say a few words. It also turns out, as I've written in other forums, that when we look at how history unfolds over time, I think that can also be helpful to constitutional interpretation, because we don't have the luxury as legal scholars of running experiments like scientists in labs, but we can look at historical episodes to sort of glean what the normative stakes are in some of the debates that we're having. And I think principally in my context and what I write about World War II and the mass incarceration of Japanese Americans, I think that tells us a lot about debates about the separation of powers and executive detention. It's also the case, I think, that when we look back, sometimes we can find quite a lot of information about some of the things that we debate. And I think in particular, when we look at executive detention, as I have in a lot of my work, there is quite a lot of information out there to help us make sense of the debates that we have today. In particular, I think when we study practices related and traditions related to suspension and habeas corpus and what the privilege was understood to mean, and more generally the scope of executive detention, there is quite a considerable amount of evidence out there. And this is an area in which I think it's fair to say the founding generation were heavily influenced by the backdrop of English and British legal tradition and what they had lived through during the Revolutionary War. And we see that they were influenced in this respect on, as I've hinted, both fronts. A fear about a president who would have kingly powers, but also a fear about legislative powers and legislative usurpations of liberty. And so when we look back at this, what we find, and hopefully this speaks to the larger theme of the panel, is that history really strongly influenced how they thought about writing the Constitution, and particularly the drafting of the suspension clause. So I want to tell a little bit of that backdrop and then step back and say how that story has unfolded, what it tells us in terms of lessons about what we have today in terms of the executive and Congress and how they think about emergency powers. So in very brief, I want to give a little bit of history on the suspension clause. Some of you have heard longer versions of this. It's based largely on a book that I wrote called Habeas Corpus in Wartime. The story simplified is really a story of the colonists reacting again to English and British legal tradition. The short version starts with the case of the five knights who are imprisoned by the King of England because they won't loan him money under force. And when they bring a habeas action, they are told by the Court of King's Bench it can't do anything for them. They have to seek mercy from the king, who of course was the person who threw them in the Tower of London to begin with, or in that case, I think, Fleet Prison. One of their lawyers is John Selden, the great John Selden, great legal scholar and parliamentarian. He begins a push to start to limit the power of the king to put people in the Tower of London. Again, I'm simplifying considerably. He helps push through the Petition of Right, which is seen as a rebuke of the king. And eventually, to underscore that his efforts really were for naught, the king throws him in the Tower of London summarily. But all of this leads up to the English Habeas Corpus Act of 1679, which I think in American constitutional tradition was really influential. And you see that influence well through Reconstruction, and then suddenly everybody forgets about it. But it's really, really important because it's part of Parliament taking more power for itself from the executive and taking control in particular of the law of executive detention. And in so doing, requiring that for someone who can claim the protection of domestic law, they have to be tried in due course on criminal charges, or else they can go into court and win their release through a habeas petition. And judges under the act were required to give them their freedom under threat of penalties. So the Habeas Corpus Act is a really, really big deal. It's effectively a game changer in the law of executive detention. The colonies, meanwhile, they want this. They're reading about it. Whether glorified too much or not by Blackstone, he's calling this act a second Magna Carta. And you see time and time again that in the colonies, the early Americans, they want these protections too, because they're not experiencing them. Even though this is the law as it's playing out in England, here in the United States, or what would become the United States, you still have executive detention without check, summary executive detention through lots of different ways, including especially against the backdrop of habeas claims that are denied because there's no Habeas Corpus Act here. And when the colonies try to adopt it as their own, it's vetoed. So this is part of the story that leads to revolution, and it is a big issue for the founding generation. They also lived through suspensions on both sides of the Atlantic during the Revolutionary War. So England has a suspension that is put in place at the urging of Lord North in order to hold American traitors or rebels, as they are called by the Act, just like other prisoners of war. That's how he introduces it. And that is because ships of Americans are showing up on English shores, and as Lord Mansfield advised the administration, if they make a claim under the English Habeas Corpus Act, because your position is they owe allegiance to the king and they're traitors, they will be set free if you don't charge them and try them for criminal activity, which the administration did not want to do. But over here, remember, there was no English Habeas Corpus Act, but the new states, as they're claiming independence, one after another enact or adopt their own habeas corpus acts. And so then what we see immediately on the heels of that are a wave of suspensions in these new states during the war. All of this is to say this was history and backdrop against which those who wrote the Constitution had lived, and it heavily influenced how they thought about executive detention, and both executive power as well as legislative power. Just to underscore the influence, one example I love to throw out is the Georgia Constitution of 1777, which has a habeas clause that says the principles of the English Habeas Corpus Act are adopted as our own. And that's it. As though, everybody just knows what that means. And then to underscore the influence, they appended the actual English Habeas Corpus Act to their Constitution when they circulated it. So very, very influential. What does that mean? It means that the founding generation was really nervous about unfettered executive authority to detain, but they also did something that hadn't happened in English legal tradition, except in Ireland in 1781. They included a limitation on the power to suspend. It could only be suspended in times of rebellion or invasion. That is the other side of the coin. They are nervous about unfettered executive discretion, but they're also nervous about a legislative power to suspend. So they're going to limit that as well. Now, the story of executive detention changes dramatically over the course of American history. Many of you know some of this history. Abraham Lincoln's a big player in it. I think the changing of the story tells us a lot about where we wind up today. So just in brief, a few of the highlights. As we all know, Lincoln suspends on his own ahead of Congress. Now, here I'm going to go back to something Michael McConnell said this morning. You made reference to judicial opinions that sort of blithely throw out, we don't have a king. Well, we get one of those in the context of Lincoln. We get it from Tawney, who writes in Ex parte Merryman, there's no way he has the power to just, throw somebody in Fort McHenry. They have to be charged with the crime if there isn't a suspension, and the president can't suspend on his own, as Lincoln had done. Even the King of England didn't have this power, Tawney says. Well, quote Tawney lightly, but I think he actually had his history correct. He throws in John Selden for a good measure. But this really is a major pivot point in this history, because not only does Lincoln do this, Congress sits on its hands for 2 years, and it's not until 1863, well after Lincoln has, by that point, suspended habeas throughout the entire United States, that Congress finally passes legislation and says, oh, actually, this is our power, isn't it? And gets in the game. And that really changes the narrative of suspension and executive detention. I used to think that the narrative changed in World War II with FDR. But I did a roundtable on my book with some international scholars, and it took my friend who's a British scholar saying to me, what are you talking about? It's all Lincoln. You Americans, you revere Lincoln, but he's the villain in this story. And I don't want to call him a villain, but I do think my friend was right. Like, this is really where the narrative changes. So by the time you get to World War II, and FDR is told you have to suspend habeas in order to, in turn, as they said at the time, detain Japanese American citizens, and his Attorney General tells him this, his Secretary of War tells him this, his close advisors tell him this, and I've written about this a little bit in the last book. I'm now writing a book on the Endo case, which led to the closing of the camps, and getting even further into this, and it's absurd how many people are telling the president this. The Attorney General is going around in 1943 giving speeches saying everything we're doing is unconstitutional. while he's defending Korematsu and fighting against the Indo case and the Hirabayashi case. In all events, FDR is like, I don't need a suspension. Congress doesn't think I need a suspension. We're just going to do this, because that is how much executive detention and the law of executive detention had shifted by that point in time. And then to underscore it, in the wake of World War II, you have J. Edgar Hoover recommending what ultimately becomes the Emergency Detention Act, which is, I will say in Hoover's favor, he said you would have to have a suspension to hold suspected communists. By the time it gets to Congress, they pass the law allowing for summary detention of suspected communists, but they specifically say they're not suspending. They don't think they need it. And that's now the law on the books, or at least on the ground by that point. And that's how we wind up with a decision like Hamdi during the War on Terrorism, in which the Supreme Court, cobbled together, says there's nothing in the Constitution that prohibits this concept of a citizen enemy combatant, somebody being held and alleged to be a terrorist without a trial, without a suspension. And so that's where we land. Now, what does that tell us about the Constitution and history and the separation of powers in emergencies? I think it's part of a larger theme by which we have seen the ceding of emergency powers and control over them from Congress to the president. And also, this is not a new theme. We've seen the court really on the sidelines of all of this. Although, notably, Anne made mention of COVID. I've been also on the side writing a paper on the recent COVID decisions that are COVID specific, and we do see some very aggressive judicial review in some contexts, which is quite, I think, noteworthy against the backdrop of a very deferential emergency court. But going back to the Congress and the president, and I'll just say a few things and then I'll wrap up. Today, not only has the president really effectively claim the authority to engage in summary executive detention without a suspension, we have an apparatus whereby, just to give some examples, the moment the president declares a national emergency, more than 100 special provisions become available to the president in terms of emergency powers. And I will note, the last president declared more national emergencies than any other president in a 4-year period. And if you look back to the reforms that set up the modern emergency state, in 1973, when the Senate studied emergency powers, they found that there were 470 outstanding delegations of emergency authority to the executive. And the same committee, I love this statistic, discovered that multiple presidentially declared emergencies remained outstanding, and this is again in 1973, including a 1933 proclamation by FDR that suspended all transactions at banking institutions in the US and its territories for 4 days. So another modern example in the war context is the AUMF. We haven't had a new AUMF since 9/11, even though our foes have changed and terrorism has morphed and the threats are largely different. What we have is a Congress that is really disengaged in all of this. And so when you put that together with a judiciary that has largely been on the sidelines, and you have a Congress that is disengaged, and particularly as I've tried to play out and talk from my own work about the context of executive detention, where it really has ceded leadership powers on the issues, what you have is that executive power now operates often in the absence of any congressional engagement, and often, not necessarily always, maybe we'll see if the COVID cases pose a shift or represent a shift in judicial review, but largely toothless or deferential judicial review. To give an example, you have Frankfurter in the Korematsu case saying, we're not necessarily approving what's happening with respect to everything that led to the mass incarceration of Japanese Americans, but he has this line, he says, that is their business, i.e. Congress's, not ours, as though it's not up to the court to police detention at all, and everything that led up to it. But what we have now is a modern executive that is quite powerful, and at least in the context of executive detention, looks an awful lot like the king. at least the king that provoked the reactions of the English Habeas Corpus Act and other things that followed in its wake. And that is really quite noteworthy to my mind, because it suggests that we've really forgotten some of the core impetuses and purposes behind some of what drove the revolution, drove independence, and drove the creation of our republic and the way we thought about liberty. And that is quite significant. And the question, it seems to me, is what, if anything, do we want to do about it? So I'll stop there. I could have said a lot more. I was going to talk about Churchill, but I left that out. If anyone wants to ask, I will.
With Churchill to the side, we'll turn to some comments. First, Bijal.
Hi. Thanks to the organizers, and thanks for inviting me to the conversation. I should say right off the bat that this is sort of outside my field of methodologies, but I'm happy to be here and to be participating. So I enjoyed this essay. I haven't had a chance to read your book, but I look forward to checking it out. I think that originalism has been accused, for better or for worse, of sometimes cherry-picking historical practices in order to justify current practices. And so I was struck by the sort of broad tension that you identify, that Julian spoke to this morning, that even though the power of the president was developed with the intention of avoiding a monarchy, that some of today's originalists are keen on finding justification for strong presidentialism. So I think your paper really highlights the importance of the essential story of king as foil for originalism. More specifically, I like the idea of exploring the origin of habeas jurisprudence as a means to check the executive, and potentially drawing on this historical practice to constrain today's plenary power doctrines. It's interesting to note that originalist methodology is emphasizing plenary powers focus on aspects of the monarchy that not only the colonies but also the English themselves disliked, and that were changed in England before American systems of presidential and congressional law were established. So I enjoyed your discussion of how the English Habeas Corpus Act, despite being the second Magna Carta, as you put it, or as Blackstone put it, I guess, was nonetheless inaccessible to the British colonies, and how this was a key factor for driving the move toward American independence. So in other words, this is important context, in my view, for understanding the original boundaries of presidential power. So I agree, if the suspension clause is read with this context in mind, cases of rebellion and invasion of public safety should be understood as narrow exceptions to habeas protections, in addition to the fact that, given the placement of this clause in Article 1, as you know, these exceptions to habeas rights are to be made by Congress, not unilaterally by the president. I thought the comparison between Roosevelt's unitary approval of the detention and imprisonment of Japanese Americans and Churchill's push, so I'll mention Churchill for you, right? Churchill's push to shut down internment in England was interesting. And so I had a question, a methodological question, I guess, related to this, which was, I wondered how we use concurrent British events to provide context for American constitutionality. So in other words, is it legitimate for American scholars to draw on England's present-day interpretations of law that serves to some extent as the foundation for the US Constitution? Or is this a misconstruction of methodology? In any case, I think your point that the ever-increasing presidential plenary power to detain is a present-day failure of the separation of powers between the political branches. I think this is a good, important point. I think you illustrate it vividly in the project. I thought your use of Frankfurter's quote from Korematsu, the Korematsu concurrence, was sort of an evocative example of the failure of the courts to properly arbitrate the distinctions between the political branches. So I think that many take this court, and I think this is how you also sort of frame it in your remarks a moment ago. Many take this quote that the court's holding should not be read as approval of that which Congress and the executive did, that's their business, not ours, as meaning that the court doesn't condone the substance of the policy, right? The constitutionality of imprisoning Japanese Americans en masse. But you highlight that it also shows how the court abdicated its role in determining whether the policy was constitutional as a structural matter, right? In other words, whether the fact that the internment was the result of unilateral presidential action violates constitutional requirements of the separation of powers. So those are sort of two distinct ways of understanding that quote, and I think the second one is sort of a newer one, and interesting if that's what you're furthering. So again, I could be wrong. Okay, so finally I have a question that relates to my own interest in how plenary power operates in enforcement, bringing it to the present day because that's what I do. And so I wondered how your insights apply to contexts in which the president's power is increased incrementally as a result of discretion granted by Congress, as opposed to by means of sort of a large-scale blockbuster directive by which the president wrenches control away from the legislature, right? So the AUMF is one example, that you note in which Congress has ceded its power by not updating the policy or acting in response to potential presidential abuses of power. And so another, in my mind, is the immigration context. Adam Cox and Cristina Rodriguez, among others, have noted that Congress has given the president so much control and discretion over the back end, over the enforcement of immigration law, that the president, in their view, has been rendered effectively a co-principal as opposed to an agent of the law in this context. And they argue that this is a good thing, from a progressive perspective, which is an interesting argument, I think. But I wondered if, from your perspective, we should be concerned about this, and if so, how you would ground your concern. Thanks. Great project.
Anne, should I respond or should
Why don't we
wait?
get Chris, and then we'll give you a few minutes to respond.
Yeah, so I just want to say it's so great to be back at my alma mater after 16 years after graduating, and it's a particular thrill to be on the panel with Professor O'Connell, one of the greatest administrative law scholars today, and just so thrilled when our alma mater stole her from the school across the bay.
Ouch.
So this is
Painful.
Exciting. I don't have a ton to add, but Michelle kind of hit on the last part I was interested in was, as I was reading your piece, I kept on thinking of Tino Cuellar's book, Governing Security, and kind of the story that, like, what we consider to be an emergency or what we consider to be national security has kind of morphed as we've gone on, and that presidents use and declare emergencies in ways that probably aren't consistent with what the Congress that passed, like the National Emergencies Act, or would have done. And I'm kind of curious, like, how that plays out in the story. I mean, I understand it doesn't play out directly in your story, but in the broader story of presidents using emergency powers, and in particular in the context of immigration, and with whether it's declaring an emergency to build a wall, or the way that we detain non-citizens with the remain in Mexico by, I guess, not detaining, but not or in the United States in other ways. And I'm just kind of curious to see, like, are there lessons from kind of your larger, research on the history of executive detention that bear on the way that immigration detention and enforcement has played out over the last few decades?
Yeah, so this is a great comments. Thank you both so much. Thank you for engaging with the work. I put up a short paper that's an outgrowth of the book and some other things I've been thinking about and writing about lately. You gave me my hook, so I'm going to talk about Churchill. I think it's a really interesting question that you pose about, well, what, if any, relevance does modern UK interpretation or discussion of earlier UK law or contemporary UK law have for us? I've not used it in my work. I have a whole article on the FDR-Churchill comparison that I published with the California Law Review. They were my students. They had to take it. No, I'm just kidding. That's a terrible thing to say, especially since we're being recorded. They did just turn me down for one, so I think that lends credence to their legitimacy. Okay, being serious, the Churchill example I think is really fascinating for other reasons, and I've used it for other reasons. Not so much that it tells us what our law is per se, what they're saying their law is, but it is kind of interesting to look at how, for example, their courts were interpreting the concept of habeas during the World Wars, because they do have the same origins, right? We are sort of branches off from the same basic law. What I've used Churchill for is really a foil to FDR to show there are two different ways an executive can think about constitutional norms and traditions. And in this particular context, they are really different. So FDR says, in so many words to his Attorney General, I don't care about the Constitution, that's the court's issue. The court is supposed to be policing it. And Biddle writes in his memoirs, I don't think the Constitution ever greatly bothered a wartime president. It certainly didn't bother FDR. It was for the courts, in his view, to clean up and tell him when he'd gone too far. But Churchill, interestingly, as you highlight, as I noted, he's the leading voice to shut down their program. And so what is fascinating to me about that is he's a counterexample of an executive who says in private correspondence and then publicly, we have this great tradition of habeas, and it means that we don't just lock people up without a trial, unless, we used to do suspension, but that's a really dramatic thing. And he says in so many words that this leads toward totalitarianism. And of course, this is all during World War II. So that's a powerful thing to say. And it's for that reason, he says to his Home Secretary, we need to shut down our program. And he says in one letter to him, history will remember you well, even as people are effectively throwing stuff at you right now, right? And this is really unpopular. And it would be hard to overstate how unpopular shutting down Regulation 18B was at the time. But I do point out when I've written about this that there are some really important caveats. So there's no general election for Churchill during the war. That's a big one. Race, the elephant in the room, is a huge one. The people being locked up in England include two cousins by marriage to Churchill. Okay, so race and class, like he can relate to the people being locked up. One is his wife's cousin. So those are really different, and the numbers are small. The numbers are really small as opposed to here. But I think it's really interesting to think about the separation of powers and the potential for an executive to self-police for constitutional values. His example suggests in this one context maybe, but I think American history and the way we think about the courts, at least, or as Madison, for example, thought about the courts and sold the courts with the Bill of Rights, is very, very different. And that's why I think the fact that arguments that an executive can self-police, to me, they're not very convincing. Because instead, I think we have the FDR, who's standing for election and who will not, under any circumstance, close the camps until after the 1944 election. And even then, he still doesn't do it. It's only when he's tipped off that they're going to lose the Endo case that he finally says, okay, let's do it. So briefly, on the Frankfurter quote, yeah, I am suggesting that second reading as well. I think there's more to it. It's not just that he's saying, hey, we're not approving. He's also saying this isn't our job to be policing this. And I think it was Eugene Rostow who wrote shortly after these cases, what is the court's role, if not to say when an arrest and imprisonment is illegal? I mean, really, isn't that like the most important thing courts do? I agree. So for your latter comment, and Chris, your comment about discretion, I mean, I think this is a much, much bigger issue. I'm talking about emergency powers, although, Chris, you give the example of invoking emergency powers to deal with immigration. But even just more broadly in immigration, you see broadly worded statutes that give presidents huge amount of authority. And, a lot of people, I think, look at, for example, the decisions made by the Obama administration and the Trump administration in the immigration context and say, boy, these are like big policy decisions. Maybe it would be better if Congress was making them, but it's another example of where Congress, for any number of reasons, and obviously we could tease those out or talk about them, doesn't seem to want to engage. And so what I'm talking about in the emergency powers context, I think, is part of a broader theme that we see, a Congress that is doing less and less, and that doesn't seem to, for the institution's sake, want to come together and say, hey, we're ceding all this authority to the executive. And I think, there are certainly very formidable arguments. That's not a party issue. That's a Congress as an institution issue, but the party stuff is outweighing all of it. And so Congress isn't coming together and protecting its, for lack of a better word, turf. And so we're very far removed from, I think, how this was supposed to work.
Great. We'll move to Bernie for her presentation. Great, thanks. And thanks so much to Jed and Michael for including me, and also to Morgan for the fabulous organization that everyone has mentioned already. So I'm going to be turning to a different kind of emergency power and talking about Jefferson pardoning and emergency power. And I was struck in the first panel at the discussion of the question of enumeration and how tied executive emergency power is to enumerated powers or unenumerated ones. And the pardon power is a very precise enumerated power that draws in many ways on preceding British practice, which goes along with what we just heard about habeas. But I really want to focus in on the pardon power and its use as an emergency power and how we might deploy it, but especially to think about what counts as an emergency. And so what is the nature of an emergency? What kinds of emergencies are there? I think we might get into this a little bit more later when we turn to what Anne mentioned in terms of thinking about COVID and emergency powers, because I think that we might distinguish between the kinds of emergencies that involve rebellion or invasion and the kinds of emergencies that are caused by non-man-made incidents. So, part of what I want to talk about is a little bit about, kind of the kinds of emergencies that give rise to the use of executive power. So Hamilton famously promulgated a kind of emergency powers view of the ability to pardon in Federalist 74, claiming that, quote, in seasons of insurrection or rebellion, there are often critical moments when a well-timed offer of pardon to the insurgents or rebels may restore the tranquility of the Commonwealth, and which, if suffered to pass unimproved, it may never be possible afterwards to recall. Jefferson, by contrast, expressed skepticism during the same time period, the late 1780s, about the continued need for pardoning in a more enlightened Commonwealth. Nevertheless, when he became president, one of Jefferson's first gestures was to pardon those who were still jailed, who had been convicted under the repealed Sedition Act. Furthermore, he issued many more pardons in general, 119 total, than had his presidential predecessors. So, here we might see a difference between Jefferson as a kind of theorist of constitutions versus Jefferson as an actual president. And we might say, did this sequence of statements and events mean that Jefferson had just changed his mind, maybe due to his different role, about pardoning in the time between his work in Virginia and his assumption of the presidency or his conduct of the presidency? And certainly people have shown that Jefferson changed his mind about a lot of things in the intervening time. But I want to suggest here that actually this change or seeming change doesn't actually represent a transformation, and that rather Jefferson remained consistent about the undesirability of pardoning as a routine matter, but viewed it from the beginning as a valuable tool for responding not only to emergencies of the Hamiltonian kind, but also to the emergency posed by cruel and unjust laws. This kind of emergency came not from the revolt of a few, but from a majority's overly coercive imposition of their will on a minority. In this respect, we might see some of Jefferson's rationale for pardoning as prefiguring critiques of populist democracy. Okay, so Jefferson's early view first. First, I want to flesh out Jefferson's early statements about pardoning and its place in a commonwealth, largely taken from his considerations of the Virginia Constitution and plans for the revision of that. In their book on Jefferson's notes on the state of Virginia, Dustin Gish and Daniel Klinghard suggested the work should not be seen as only responding to a scattered set of questions, but instead as articulating Jefferson's vision of the Republican form of government that he believes should also prevail in the US Constitution. In at least one instance, Jefferson's legal commonplace book also cites to a series of authorities that find their way in identical form into the notes on the state of Virginia. So I'm going to think about the legal commonplace book and the notes on the state of Virginia together. More generally, I think certain recurring interests manifest themselves in the two works. Among these is the interest in the reform of and softening of criminal law. Jefferson had read widely among Enlightenment thinkers, as demonstrated by the set of citations in the legal commonplace book. There, he wrote that Montesquieu, popular in late 18th century America, felt the pardon power necessary only under a monarchy.
He also recorded passages from Beccaria's Popular on Crimes and Punishments, expressing the view that clemency would become obsolete as punishment became less harsh. For many Enlightenment thinkers, pardoning was too dependent on personal favoritism and the whim of the king and sidestepped a more systematic reform of criminal law. Under the influence of these Enlightenment thinkers, Jefferson explicitly eliminated the power to pardon in his 1776 draft Constitution for Virginia. There, he denied to the governor or state executive official the, quote, prerogative of pardoning crimes or remitting fines and punishments. But he didn't only care about taking that away from the executive, and this also echoes a bit with the earlier presentation, but he would also have barred the legislature from pardoning. So there's a suspicion of legislative activity as well as executive. At the same time, Jefferson rejected capital punishment for all crimes but murder and certain military offenses, and generally advocated for a milder administration of justice. And the notes on the state of Virginia, consistent with this, in various sections suggest revising parts of the common law that Jefferson thought were inconsistent with republicanism, including parts of the criminal law. So he suggests that, quote, pardon and privilege of clergy are proposed to be abolished, but if the verdict be against the defendant, the court in their discretion may allow a new trial. The abolition of pardon and privilege of clergy might on first blush seem inconsistent with the general support for moving away from cruelty and punishment. But on looking at the Legal Commonplace book more closely, they seem quite consistent with the thrust of the work on criminal law that Jefferson approvingly records. While most of the sources that he copied into the Commonplace book suggest the inadvisability of a retributive conception of criminal justice, and instead a more societal betterment view of criminal justice, they at the same time take aim against perceived relics of a more brutal system of punishment. And so he winds up quoting sources that basically criticize pardoning, benefit of clergy, trial by battle, and asylum as all relics of this kind of earlier system. And the authors that he cites to suggest that by rationalizing criminal law, the need for these exceptions to the purview of criminal law should be eliminated. And so I won't go through a lot of these passages, but he quotes Pufendorf and others along these lines. So then the question is, why in his presidential practice did Jefferson pardon so many and engage in pardoning so prominently with respect to the Sedition Act? Review of Jefferson's general practice of pardoning doesn't suggest an indiscriminate application of mercy. Instead, he responded on several occasions to petitions that were presented by those routinely administering the law, including jurors and judges. He further indicated a desire for the support of the judicial system more generally when he was going to issue a pardon. So in a letter from 1806, he explained that, quote, I have made it a rule to grant no pardon in any criminal case, but on the recommendation of the judges who sat on the trial and the district attorney or two of them. I believe it a sound rule and not to be departed from, but in extraordinary cases. So here we see that with respect to pardons coming out of kind of ordinary criminal matters, Jefferson wanted to routinize the application of the pardon and avoid a display of sovereignty along the lines that some of the Enlightenment thinkers he talked about had discussed. But he did grant pardon in cases of rebellion. He had famously previously supported, quote, a little rebellion now and then, unquote, in a letter to James Madison, and said in 1787 that the remedy for a rebellion in favor of liberty is to, quote, set them right as to facts, pardon, and pacify them, unquote. Presumably for similar reasons, Jefferson pardoned army deserters in Louisiana on several occasions. This kind of emergency pardon, I would suggest, resembles that which Hamilton had advocated for in Federalist 74. Jefferson's pardon of those convicted under the Sedition Act represented a different kind of emergency pardon, I would want to argue. Although Jefferson didn't give an explanation in the pardon itself, for various reasons, his speeches and writings against the Sedition Act demonstrate that he believed the act itself to be unconstitutional. While Jefferson's inaugural address struck a conciliatory tone, it also talked about the problem of legislative excess, one that presumably led to the Alien and Sedition Acts. In talking about this difficulty, Jefferson suggested that, quote, though the will of the majority is in all cases to prevail, that will, to be rightful, must be reasonable, unquote, and that, quote, the minority possess their equal rights, which equal law must protect, and to violate would be oppression, unquote. So by suppressing political dissent, the Sedition Act had produced precisely this kind of oppression. As Jefferson's speech implied, the Sedition Act had violated a basic principle of legality by creating unequal law. The guiding norms of equality and the common good, to which Jefferson referred elsewhere in his address, therefore justified overturning the effects of the law through the exercise of the pardon power. Jefferson's use of the pardon as this kind of emergency power was in service of, rather than undermining, his Enlightenment goals for criminal justice. It had turned out that Congress had not made sufficient progress toward an enlightened system to eliminate the escape hatch that pardoning provided. Jefferson's pardons as president might represent a disillusionment with the possibility of the kind of legal progress that he sketched in the notes and the Legal Commonplace book. Yet they remained consistent with his earlier critiques of pardoning, ones that had been based on the assumption that the legal system was close to reaching an end state of justice and equality. Possibly extrapolating to the contemporary moment, one might see in Jefferson's Sedition Act pardons a basis for a kind of emergency pardoning distinct from, but just as crucial as that which Hamilton had foreseen. So I look forward to Anne's comments. Thank you so much.
Thanks, Bernie. So I'd like to take up 3 points in Bernie's paper in thinking about modern clemency. So a point on procedure, a point on motives, and a final point on rebellion. So first, thinking about the process of obtaining clemency, as Bernie discussed, Jefferson talked about writtenization of a process for obtaining clemency. And since the 19th century, the Department of Justice has had a process for requests for full pardons as well as for commutations of sentences, a process that takes over a year. Of course, this process is not in the Constitution. It is, for some of my students sitting in the audience, administrative law, with regulations and agency officials. And so when we think about Jefferson and the preference for writtenization, and then thinking about modern times, one thinks of Donald Trump. And so President Trump essentially, in almost all cases, ignored the office of the pardon attorney. And so drawing from a piece by Jack Goldsmith and Matt Gluck in Lawfare, talking about the sort of lack of writtenization. So I'm quoting here from their piece, right? It is not news that Trump has disregarded the role usually played by the office of the pardon attorney. The Washington Post reported in February 2020 that White House advisors, led by Trump's son-in-law, Jared Kushner, has taken more direct control over pardons and commutations, with President Trump aiming to limit the role of the Justice Department in the clemency process. And what Goldsmith and Gluck do in their Lawfare post is to actually look at the database and gather some of their own empirical data, and they say that of 94 grants of clemency made during Trump's tenure, that's not actually to 94 individuals. Some people like Roger Stone received multiple grants of clemency. That 41 lacked a petition in this database maintained by the Office of the Pardon Attorney. And Goldsmith and Gluck say, quote, these include some of the most prominent and controversial grants of clemency, included those issues to Roger Stone, Paul Manafort, George Papadopoulos, Michael Flynn, Charles Kushner, and 4 Blackwater contractors. And so they find for others that there was a petition in the administrative system, and then for about a third of the cases, they find that they were probably actually recommended by the pardon attorney. So with regard to this first point on process, we see, at least in the previous administration, a lack of regard for what Jefferson wanted in terms of writtenization. So the second point is about motives, and so Bernie mentions that the Enlightenment thinkers and Jefferson thinking about clemency as a response to the harshness of the criminal law. So in thinking about modern administrations, Goldsmith and Gluck, among others, criticized the Trump administration for justifications for clemency not being sort of in response to kind of harshness of the system, but rather to, as they put it, the clemency system is dominated by insider access to the president and almost exclusively serves the president's personal and political goals and whims. And what I find interesting is not all to just be a pile-on in terms of the last administration, is how this administration has actually turned to the language of the Enlightenment thinkers in terms of its use of clemency. So by no means is President Biden sort of actively using his clemency powers, right? He used his clemency powers for the first time just last month with 3 full pardons and commutations of about 7 sentences, but they involved nonviolent drug offenders, right? So the Washington Post, in reporting on President Biden's use, said, right, the announcements signal a far more targeted use of his authority than employed by former President Donald Trump, who granted pardons to political allies and celebrities who ran afoul of the law, among others. Biden's actions follow calls by criminal justice advocates to grant leniency in a system that often disproportionately affects people of color. And then the third point I just will make briefly is about rebellion, and as Bernie describes Jefferson's support for using pardons in cases of rebellion, and maybe to leave a question for Bernie with regard to the modern day and rebellion, and thinking about January 6th, right? So we know that President Trump considered blanket pardons but didn't issue, and of course President Biden did not issue. So I guess my question is, in thinking about Jefferson's writings, like how do we think about President Trump and President Biden's kind of inaction sort of in light of those thoughts? So I'll leave it there, and then I think Chris might also have a few thoughts.
Yeah, I kind of like reflecting on both of these wonderful projects. I'm probably over-reading the Pardon Project, but it's interesting to think of one being a story of the president using an emergency to take away liberty or infringe on liberty, and another using a story of an emergency rebellion to actually kind of be more liberty enhancing. And as I read those papers, I read the kind of the short remarks that you circulated last night together, I kind of had this thought of like, when it comes to courts, similarly, do we have a deferential emergency court? Is that what we should have, or is it the opposite? Should we have more search and review during an emergency? And maybe it's not just a court, maybe it's a president as well, but I did kind of thought that was an interesting contrast between the two papers.
Thank you so much. Can I just respond?
Yeah.
For a few minutes? Yeah. So these are wonderful comments and questions, and raise a whole host of issues. I think, I actually hadn't, until I was launching into this, realized that Jefferson was really interested in sort of creating a process for pardoning, and it harkens back to at least one kind of earlier tradition, which was, these kind of more routine administrative pardons in the English system that were in contrast to the more sensational ones. So I think it is really interesting that sort of closer to the founding, he tried to establish a kind of administrative procedure for pardoning way before there arose the office of the pardon attorney. And I do think it's really quite noteworthy how few pardons Trump processed through the office of the pardon attorney, and even when a petition had been filed, he often was prompted to engage in the pardon not by the petition itself, but by someone else intervening. So I think that that was one hallmark of the kind of Trump regime of pardoning, was to avoid any kind of routinization and make it a much more sensational and kind of individual act of the president. And then in terms of the motives, I completely agree about that Biden does seem to be taking up this more kind of Enlightenment vision, and I would say maybe in a way similar to what Jefferson is doing with the Sedition Act pardons, because I think that when in terms of describing the pardons for nonviolent drug offenders, he's kind of invoking a general consensus that some laws were too harsh in targeting nonviolent drug offenders, that their efforts to, stop that kind of law going forward, but that some people are still in prison based on those laws. And so there is, in a sense, a kind of more popular consensus against those laws in the way that there was against the Sedition Act when Jefferson was pardoning people convicted under it. So I think there is actually a resonance there with that kind of Jeffersonian pardon and the sense of, kind of nullifying a law that no longer has popular support. And then in terms of the January 6th rebellion, I do think that this is very interesting. I think were Trump to have engaged in the pardons, the problem is that the way that Jefferson is thinking about pardoning a rebellion is that it's a rebellion kind of against the president or against, right? Whereas for the Trump pardons would have been, in a way, supporting his supporters, right? So that there's a different valence, I think, for that. Now, I think that thinking about it in the Biden context, you could imagine that certainly Jefferson and many others, of course, did engage in some pardons, like some pardons of deserters, on the condition that they return to kind of supporting the army, right? So you could imagine some form of maybe conditional pardon in this case that would be conditioned on some form of support of the government or support of legitimacy of the government. But the one downside there, I think, it would be to say that you're not then engaging in a sufficient investigation of what happened, right? So I think that one downside of these pardons of rebellions is the imagination that maybe the rebellion is over, or there won't be any need to kind of further investigate and figure out, if there are ongoing conspiracies. And so I would say that that might be, a downside in the January 6th case of pardoning. And then, yes, I think in terms of Chris's comment, yes, I think that, emergency can be used, I think, in either way, right? Or that there can be emergencies that, or the use of emergency powers can either be liberty enhancing or liberty depriving. And I think that it is interesting to think about them in both respects.
A quick question of Bernie.
Oh, sure, yeah.
So I wondered how much this account of the pardon power as an intervention in systemic injustice is a new sort of description, or not. So you identify Jefferson as participating in that form of intervention, and then Biden has done the same. But to me, the transparency of the Trump administration's procedures aside, and honestly, whether or not they truly believed in the innocence of who they were pardoning aside, like this idea of pardon as politicized and specific to an individual and that individual's innocence, as opposed to a sort of a broader systemic intervention, to me seems like the more sort of conventional understanding of pardon. So are you sort of contributing a new story of what pardon is with this project?
Yeah, I mean, I would say that I think that the Sedition Act pardon does represent a new moment of pardoning, right? With Jefferson really using it as a tool of, declaiming the constitutionality of something, right? So that use of pardoning as calling out injustice or unconstitutionality, but I think even more so kind of this idea of cruelty or injustice, I think is a new idea with Jefferson. So, I mean, I was inclined to kind of think of it as maybe a later phenomenon at some point, but I think that actually Jefferson really is sort of using it in that way.
Amanda?
Yeah, I just wanted to pick up on Chris's latter comment because it's really interesting. While you were talking, Bernie, I was thinking about Lincoln, and I hesitate to talk too much about Lincoln because there's some huge Lincoln experts in the room. But your comment actually hits right on it because Lincoln, as I said, he's going around suspending habeas ahead of Congress nationwide, but he also issues the Amnesty Proclamation. So he's doing both halves of these emergency powers, as you're highlighting. So that's a really good example. And I love your question about, okay, again, how should we be thinking about the courts in all of this? And I think it's a really important question. But I loved how your comment brought our papers together. And another thing that I think brings our papers together is I thought it was really interesting, Bernie, how you talked about in criminal cases, Jefferson would look to see what are judges saying. Is he being prodded to do this? Because the people who are on the front lines are saying, you know, this is not right, and relief is owing. Because Jefferson is he's a really interesting president, actually. You know, you highlight how he was somewhat skeptical of use of the pardon power, but then issues all these pardons. He's someone who said we should not have suspension. We should not recognize a suspension power at all while the Constitution is being written. What's something that he does? He's the first president to go to Congress and say, I want a suspension. So that's interesting. But more interesting to me, actually, is when you talked about how he would listen to judges and defer to judges. There is something of a respect for institutions in him. Mm-hmm. So he goes to Congress and he requests a suspension. This is ridiculous, by the way. It's to address the Burr conspiracy. Congress, it sails through one house and stalls in the other. And at that point, several of the prisoners have been taken into military custody and brought to D.C. And he says, okay, I guess we lost. And so his administration turns those prisoners over to civil authorities and proceeds criminally against them. So that's another area where he's actually trying to defer to the criminal process and work within the law, which is kind of interesting.
Yeah, although there's also another qualification there of something that I haven't figured out how to put into my story either, which is that then he gives pardons to some of the conspirators in order for them to testify against Burr, right? So, I mean, maybe that relates to January 6th also, but yeah, I think that you know, there is some sense of kind of manipulation of the process in that.
He's going to push the envelope, to be sure.
So I want to just kind of ask a follow-up. When Ann framed it as like Trump, you know, using it for political gain and Biden not, I mean, my kind of reaction was, well, no, Biden's playing to his base, and he actually hasn't pardoned anyone other than one person. Like, if anything, he's, you know, just playing to the political polling that every president does. And I kind of wonder along those lines, like when it comes to Jefferson, like, was this a Churchill moment where he was pardoning people that it actually affected him negatively, or was this actually either low stakes or positive for him when he was doing it? I'm kind of just curious.
I think it was definitely positive because also, I mean, along the same lines as with, you know, Biden pardoning people under, you know, convicted under laws that a lot of people would acknowledge are overly harsh. I think, you know, already the Sedition Act had been repealed when Jefferson issues this pardon, right? So there's at least enough political support that he's not actually entirely going against, you know, the will of the people through this. Yeah,
that's interesting.
Yeah.
So I thought maybe just, we'll end early, but I have two questions. One more relevant to the papers on the panel, and one paper that was written by someone sitting up here, but not actually circulated. And then we'll kind of move to COVID. But the first question is to Amanda and then to Bijal, who has a related paper. And the question is this. Kind of what do you believe is the desired role of Congress, in particular executive action, and whether that your view changes in emergencies? So Amanda, obviously some of that's in your paper, and Bijal has written some about that too.
That's a pretty broad question.
I know, think about it as, you know, imagine like a panel question in class. You have no more than 3 minutes to.
Woo. I'm on call in Professor O'Connell's class. I don't know about this. You don't teach at my law school anymore. Oh, sorry. I'm getting punchy. It's late on a Friday. So I think Congress needs to be involved. And this is where what I said at the beginning of my comments comes back. And I only alluded to this, but I think history has shown us, as we've watched it play out, that where Congress doesn't stay engaged and the president, for better or worse, and you know, there are very good arguments to be made that in some respects this is for better. The president is focused on winning a war, if we're at war, for example. And so the president, you know, again, for better or worse, we know historically this is what is going to happen. The president is going to be focused on that. FDR, Lincoln, choose your examples, World War I, the suppression of speech, other things, right? So to have the president sort of going at it without congressional engagement, without greater democratic engagement, without a court that's engaged, has led to some really problematic results. No free speech during World War I, locking up 120,000 Japanese Americans, 70,000 of whom were natural-born American citizens, for average length of time of 3 years during World War II. These are not happy precedents. And so I think as a general proposition, it's the idea that Congress should be involved. And if you're an originalist, you should really want Congress involved, particularly in the war-making power, because as John Hart Ely and others have shown in their work, that was the idea. And the idea was, we don't want to go to war lightly. We want a clunky system that makes it hard to go to war because it is a big deal. And so part of that idea was the more chefs in the kitchen, even if that is clunky, that's better among the various menu of options. Was that under 3 minutes?
That's great.
Am I going to pass the class?
Everyone passes.
That's not what I've heard about her class. Just no. I shouldn't have said that. There are students here.
Oh, no. Oh, I
I'm
see red
kidding.
under the mask. So I guess I'll take 30 seconds to a minute of my 3 minutes to sort of provide some background on this paper that Anne is so mysteriously referring to.
It is a great paper, so you should download from SSRN.
Thanks. Yeah, it's a contribution to the annual review of administrative law. And in this paper, I'm looking at the impact of presidentialism from Clinton through the Biden presidencies on agencies' fidelity to statutory law, and sort of the role of statute or legislation in constraining presidential administration. So, I take the view of Article 2 that echoes the Julian's from the first panel. So Article 2 is a source of presidential power to engage in discretion that gives the president room to reshape the reach of laws enacted by Congress. But this is to be wielded not as a means for the president to gather authority, but rather to support the president's responsibility to execute statute. And so, broadly, this paper is preoccupied with the question of what it means for the executive branch to execute legislation in an administrative state that is rife with administrative action and discretion that's influenced by the president. And it really grapples with this idea that the president's duty requires an affirmative, so I'm quoting Andrew Ethan and Jed's article, Faithful Execution in Article 2 here, not to the moderator, to the organizer, right? It sort of grapples with this idea that the president's duty requires affirmative effort on the part of the president to pursue diligently and in good faith the interests of the authorizing instrument or entity. Okay, so if you think about presidential administration on a spectrum, one end is a ministerial president, the other end is a president who does their best to sort of shape or even bend statute in order to find justification for pursuing his or her agenda. We have a presidentialism that's far on one end of the spectrum. And this paper, it's again a symposium contribution. It sort of advocates for something in the middle. And so I'm arguing here that to better uphold its responsibility to execute the law, the executive branch has to be required to reconcile presidential intervention and agency action with the thrust of statute, right? And so the kind of takeaway from this is an advocacy for statute-focused presidentialism. And so I do want to note quickly that this is not an argument against unitary executive theory. One could imagine focusing a very strong and directive presidentialism in a way that forces agencies to engage with more nuance in statute. To put it another way, I don't think a unitary executive branch has to be considered a co-principal of Congress. It could rest instead on a system of presidential control that ensures agencies engage in more exacting adherence to legislative goals. Okay, so how then might we reconcile presidentialism that is statute-focused and policies that rise to the challenge of extraordinary circumstances? In other words, if you think about statute as constraining presidentialism in far greater a way than it has been understood thus far, how can a president then pivot or sort of direct agencies to engage with emergencies? So I think that there may be situations in which a close administrative reading of statute could lead the executive branch to conclude that policy should be directed by the president, either because the statute is vague, inconsistent, or not up to confronting new challenges, or because Congress intended there to be a political role in the development of policy, for instance, in order to handle a pressing crisis. And so I think from this perspective, for instance, and this is, I think, connects to the next question I think Ian is going to ask, the CDC's COVID policies directed by Biden could be viewed as the result of statute-focused presidential administration. Rather than understanding presidential administration in the COVID context, as courts have initially suggested, to be action that's inconsistent with statutory requirements, we could understand the Public Service Health Act of 1944, the relevant statute here, as actually providing not just purchase but ample justification for anti-COVID measures. And so these policies have come under fire in the courts, right? Just in April, a district court in Florida struck down the mask mandate for airplanes and transportation, in part because this mandate, quote, exceeds the CDC's authority under the relevant statute. Last June, the CDC issued an extension of its nationwide moratorium, but this action was blocked by the Supreme Court because the statute on which the CDC relies, quote, does not grant it the authority it claims. The Supreme Court sort of says lots about this, right? It would be one thing if Congress had specifically authorized the action that the CDC has taken, but that has not happened. Instead, the CDC has imposed a nationwide moratorium on evictions in reliance on a decades-old statute, I'll quoting from the Supreme Court, and then it declares it strains credulity to believe that the statute grants the CDC the sweeping authority that it asserts. But I think that the CDC's recent issuance of both these mandates, the mask mandate and the eviction moratorium pursuant to this act, may be justified, even based in a sort of statutorily constrained version of presidentialism, because the Public Health Service Act's fundamental goal is to empower administrators to confront public health crises. And I have thoughts on both the textual and purposivist approach to sort of understanding this better. And then so the final thing I'll say is, I also think another way in which, in addition to sort of careful statutory interpretation, nonetheless lending itself to presidentialism, tools of statutory implementation like prosecutorial discretion could also support presidential administration in times of crisis in a way that's consistent with the president's constitutional duty to just enforce the law. And so one of these crises, I have a theme, the mass of non-citizens who are present in this country without rights and protections. Some have referred to this as an immigration crisis. It's been a linchpin of presidential agendas since 9/11 and before. And a Texas court last year condemned the DACA policy, which was framed by the president himself as an attempt to under-enforce a statute, right? It was framed as a version of presidentialism that cuts against statute. But Goldsmith and Manning, I think they write in a blog post or a short essay, they actually argue that prosecutorial discretion is inevitable and consistent with the Take Care Clause. And without it, the executive can't plausibly enforce the law against all that violate it. So this to me suggests that presidential administration can both be statute-focused and specify how to prioritize the enforcement of that statutory mandate, given the realities of a limited pool of resources. So some thoughts from the paper.
Great, so we'll let Chris, and then we have some questions, so we'll move from quick comment from Chris to a question.
Yeah, I mean, I remember when Vijay presented this paper a while back, and it reminded me of Judge Rao when she was the administrative law wire, gave a speech at the ABA's annual administrative law conference, and it kind of shocked me a little bit. But she said, our role at a wire isn't just to make sure that they do all the procedures right, it's also to make sure that the agency is interpreting the statute, providing the best interpretation of the statute, not a permissible one. I thought it was just so shocking, but it does resonate a little bit with kind of your approach. I'm not sure I'm not there, but I do think it's really interesting. Yeah. Actually, I'm not there, but I do think it's really interesting that that's kind of her approach when she was the head of a wire, was to figure out what the best interpretation of the statute is and be faithful to that.
All right, so we'll kind of alternate. We'll start here.
Okay, great. My name is David Paul, again, private citizen, unaffiliated. I just wanted to bring a little clarification. We make decisions within a context, the context of our place and our time. Now, there were some comparisons made between the actions of FDR, our president at the time, and the Prime Minister of England, Winston Churchill. Now, both of those individuals made decisions that I agreed with. Both of them made decisions I disagreed with. But one thing is for sure, they were present at the moment. Let's consider just a couple of threats that FDR had to consider and a couple of threats that Churchill had to consider. Anybody in here ever hear the term the Cliveden set? In England, you have an interesting situation. You have elite families who are related to members of the elite families of Germany. And so, yes, there were some people who, based upon certain affiliations, may have ended up incarcerated. Now, in terms of England, there were some people there who had investments in Germany and tended to have a pro-German perspective. Now, were their perceptions colored by their investment? I don't know. Now, on the other hand...
I'm going to cut you off in about a minute, just so we have time for the other question. So
okay, good. Then let me just race right to it. I don't believe FDR was motivated by racism when he incarcerated people who were considered Japanese. He did it based on nationality. And we were attacked by Japan, and there was concern as to threats within the United States. And I'm going to close by asking this question. Where do you think Japan got the information as to where to send their attack planes on December 7th?
I will just answer this very briefly. I am a proud Italian American, and my family was not incarcerated. I think I can say more, but I think that pretty much sums it up.
Jillian?
So, great panel. I have one comment that came up when you guys were talking just now about congressional engagement, but then I have a question for Amanda, which I hope will relate this panel a little bit to the one before. So the interesting thing about congressional engagement is also, what do we see as congressional engagement, right? And this, of course, Chris, goes back to what you and I talk often about, but there are many ways Congress can engage. Congress has trouble passing statutes that are substantive statutes these days, but it engages a lot in terms of hearings. It engages a lot in terms of appropriations. And so part of what we might want to do is think a little bit about what forms of congressional engagement should count in these contexts. The eviction moratorium is fascinating because Congress actually came in and endorsed the CDC moratorium and expanded it for 30 days. And you could read that as only 30 days. You could read that as actually sanctioning the action. But it's interesting that there actually was congressional engagement, right? It's not a case where there wasn't any. So I think one of the things we may need to do is start thinking about what counts as congressional action as certain forms become more difficult for Congress. The question for you, Amanda, and this is an effort, but I do think it connects to the panel before. One way to approach the question of removal is there's some evidence of different views at the time. This, I think, connects to Jonathan's point and to Jed's in terms of it could be that we develop over time an account of removal power. It's not something we had at the time. It's something that develops over time. That then leads to a whole bunch of questions about whether or not we can reconceive removal or whether or not we have the right to understand. But that's one way to understand the evidence. And I think Jen's comment about you've got 16, doesn't that count? Yeah, it does. It counts in terms of evidence of maybe a view that will emerge over time. So the connection to you is that you said we're using habeas, we're at a position now where we're back to what we were trying to get away from. And I guess I want to push you a little bit, but also to get clear about exactly what you mean. So one account could be that what you told us was a story of how our understanding of habeas has evolved over time. Now, Lincoln is suspending on his own is, I think, the strongest case that was at odds with what was understood at the time. Congress granting broad power that allows the president to summarily, maybe not as much, maybe it's more of an evolution of meaning over time about what should trigger habeas, in that you do have Congress involved in the president. So I guess my question for you is how much of this is a story of evolving meaning of how we understand the suspension clause? How much of this is it was fixed in time and we're now deviating from what it originally was understood to be?
Yeah, that's a great question because it highlights for me how the debates over these issues about which I've been writing, they're debates that transcend methodologies, right? So if you're an originalist, okay, I tell you a story and you stop reading in chapter whatever that is of the book, and who cares what follows? But if you're not, then what follows is really interesting, because then you can start to talk about, okay, well, what system makes the most sense? What are our core values? Is it protecting liberty, to go back to something that you were talking about? You could sort of have one or the other, right? And that's why tracing the story, I think, should be interesting to everyone, or at least that's how I tried to sell the book. But to be serious, it is really interesting in the story, because Lincoln, he is this key player. He suspends on his own, but he's meticulous in explaining time and again, I'm doing this because I can't otherwise arrest outside the criminal process. And I would have to let the Confederate leaders go. I couldn't arrest them because I don't have enough to prosecute them at this point in time. And it's the same with the soldiers eventually. And so for him, he's like really fascinating, because on the one hand, he's saying, I'm trying to do everything by the book, but Congress isn't doing anything. I haven't called them back, but there are other issues. So I got to get out ahead on that front too. And then what happens is it's sort of like a trickle. So he chips away at one piece, and then eventually the back half, that you need a suspension declared by somebody, that's the next thing that goes. And I mean, at the end of the day, for me, as somebody who's not necessarily going to stop reading in 1789, what follows is really illuminating, because what you see in World War II, to keep coming back to that example, is that if you don't have checks, if you don't have congressional engagement, if you don't have a court that cares about protecting liberty during emergencies, what you get is what we went through and what we experienced. And I will say till I'm blue in the face that the locking up of natural-born Japanese Americans, whose brothers, by the way, were fighting in the 442nd and earned the most commendations of any division in our military during World War II, locking them up there was no basis for it. And the worst part is they knew it at the time. But when you have unchecked, unfettered discretion, things like that can and have happened. And that, to me, is another reason to say, separate and apart from the originalist history, this is not the system we should have. It's really problematic, it's really dangerous, and at the end of the day, in my view, it goes against the core values that should be at the heart of our constitutional compact.
Can I speak briefly to the first part of Jillian's?
Well, we only have 5 minutes, so we just have a final question.
Thanks so much. This is a really fascinating panel. My question is actually related to Jillian. I'm going to come at it slightly from the other angle, and I have a hypothesis as to the answer, which will be provocative, and I wonder if it's right or not. And Professor Shaw, who's my colleague at ASU, this will touch on something you said at the beginning. But what was the source of power that the presidents were claiming that they had? Right? They have to have a source of power to act as well. There are 3 possibilities, only one of which seems plausible. One is it's war powers. It gives you the power to suspend, but that doesn't make sense because the suspension clause bakes that in. It says in case of invasion or rebellion. And so that's not plausible. One is a residuum of executive power, but that's not plausible because it's not in the residuum if it's been assigned to Congress. The other is the oath, the presidential oath to preserve, protect, and defend the Constitution, which maybe justifies what Lincoln did, which was, suspending habeas just in the rail lines that are necessary to come to the national capital when Congress, couldn't convene. So maybe FDR is the villain there. So I guess my question, my hypothesis is it actually just functionalist interpretations of executive power and that lead to accretions of executive power? So, here are 5 other examples. I promise I'll tick them off quickly. Zivotofsky, the nation must speak with one voice in foreign affairs. Not a single formalist signed on to that. That's a functionalist argument. Jackson's second category in Youngstown, the president can act if there are contemporary imponderables or imperatives of events. That's not formalist, but seems to create the occasion for the exercise of presidential power. President Obama's OLC memo on justifying the Gaddafi bombing and intervention in Syria. War in the constitutional sense depends on the scope, nature, and duration of the conflict. That's not formalist. Delegation is justified on the complexity of modern society. Chevron deference on the complexity of issues, and we have to defer to the executive. Those are 5 sort of functionalist moves that all lead to more executive power. And I'm wondering if now we add, and modern suspension. without Congress. And so I guess my provocative hypothesis is, if we have a big and arguably scary modern presidency, are originalists to blame or are living constitutionalists to blame? Is the provocative way I ask the question. And with that, I desist.
Are you fighting over who's
I
going to
feel
go
like I'm
first?
talking too much, which, my kids would certainly have said if they were here. I'll just say, I think it's a really interesting and very provocative and fascinating question and thought, things gives food for thought. We have, as I said, some Lincoln experts in the room who maybe can speak more to this tomorrow. I think for him there were a lot of bases, and the oath was part of it, because he's saying, I took an oath to defend this country. Am I supposed to let all the laws but one go, et cetera? But, he also points and says this is a big, giant case of rebellion. He is very much a constitutional scholar in all of this and very thoughtful about all of this. By the time you get to FDR, there's no discussion about it. They just do it. There's no discussion about it. So, and what's the court's role in all of this? The court isn't just not engaging. And then by the time you get to Hamdi, that O'Connor's opinion maybe feeds into your argument. It's very interesting opinion that says not one thing about history and says, citing welfare cases, I guess we'll balance a little national security and a little personal liberty. And as you can tell by the tone of my voice, I don't think that was a very good opinion. But I equally would say on the other side, Thomas's dissent, concurrence, whatever you want to call it, and he signs on to her bottom line, for someone who purports to be an originalist, makes arguments like, well, the president has to save us when we're at war, and totally ignores all the history in the Scalia-Stevens dissent. So, I think there are a lot of problems in this field when it comes to the intersection of executive detention and methodology.
So I think,
Let me just, there's one kind of quick follow-up I want to put to you. I always thought the big part of the story with the Japanese-American turban was Biddle rolling over.
Yes, that's
And
right.
not playing the role, in a sense that, having sworn his own oath to, preserve, protect, and defend the Constitution. Biddle seems to me to just be, from the stuff, Peter Irons, the other stuff I read, that seems just willing or unwilling to kind of step up to the plate and do what he should have done. And it just seems to me, in terms of your account of FDR, I don't know how, would it have been a different story? Had Biddle, in fact, played, acted more, been much more the conscientious actor that arguably, normatively, he should have been? Or, you just portray FDR,
Yeah.
I'm going to do it, which is fine. I think myself as a New Deal, both a New Deal and a Cook County Democrat, and 1 or 2 generations removed. But even so, as I try to reconstruct the decision-making process.
Yeah, no, that's a really great question. And as Jack knows, I'm working on a book on all of this right now. And Biddle, he doesn't come off well. I have to be blunt about this, because he goes around giving speeches after the war saying we're this great country and I worked so hard to protect the Bill of Rights. But he identified right at the outset, while this was being debated, this would be unconstitutional. It would violate the suspension clause. And in his memoirs, he traces his lineage. His family tree is literally on the inset of his memoirs, tracing back to the first Attorney General. His father was a law professor. He knew this stuff. And he said it to Congress. He said it to the president. And then in his memoirs, he says, well, I think if Stimson, the Secretary of War, had stood up to the president, that would have made the difference. But the reality is that he basically said to the president, if you run it out of the War Department, I'll get out of the way. And then what happens, and I'm finding new stuff now that Irons missed, and I don't mean that critically, I just mean I'm trying to look beyond the mass of stuff that he found. And I'm finding, for example, that Biddle was giving public speeches in 1943 in which he was saying, we are violating the Constitution by detaining citizens this way, but it's his Justice Department that is defending all the cases at the same time. And when you get into the internal memoranda about defending the cases and strategy in the meetings, he's never there. So he just basically is letting them go do their thing and going, having roast beef at dinners and giving these speeches, but these people report to him. It's really, really problematic. And another thing, and I'll stop because I know we're over, but this is another thing that's really disturbing as you get into those meetings and the memos and the early strategizing around the Endo case in particular. They introduced the loyalty questionnaire and the loyalty boards, and they start a release project. And that is tied to the Endo case. It is part of a strategy that when that case inevitably gets to the Supreme Court, the government can argue, they're here voluntarily. All they have to do is apply, and if they're loyal, they can get out. And yet the average stay there was 3 years. And when the camps are announced to be closed in December 44, there are still 85,000 people in the camps. So you can't just walk away. But all of this is all tied to the Justice Department, and it's a really grim story.
So we come to a close for today. Thank you.